The gentleman from North Carolina seek recognition.
To speak on the bill.
Gentleman is recognized.
You know, a couple things. I wonder whether anybody on the other side has any insight on this. There is, the Supreme Court of the United States has recognized a First Amendment-based right of public access to court records. And so every time currently a federal court seals a record, they go through this analysis predicated on what the factors are there. And if it's a record that falls within the concept of what they believe to be a judicial record, then there has to be any provision requiring it to be sealed must be narrowly tailored to a compelling state interest. It can't just be sort of a policy disagreement over which would be best. So I would think initially this that says essentially blanket rule, as soon as you've had a year after your conviction on a whole host of crimes, the presumption is it's got to be sealed, and the government bears the burden of showing that it shouldn't be. I don't think that's akin to the typical expunction law that's individuated, generally takes a long period of time, and the person comes in and shows they had a long history of compliance with the law. You don't have anything like that here, and you're taking something to which the public has a constitutional right under the First Amendment. There are 4 seminal cases, a couple of them in which Justice Brennan played a big role. Right now I'm drawing a blank on what their names are, but a couple came out of California. Anyways, developed over the course of the last 20, 30 years to be a very robust First Amendment protection. I think you're violating that with this statute, but I'd be curious if somebody has a reaction to it. The other thing that strikes me as I look at this is, you know, it's hard to anticipate all of the crimes that seem to be covered, because it says, you know, nonviolent crimes, and anything that other than, and then it gives a list of the things that would not be included. That leaves everything else out there. One that strikes me is financial crimes, embezzlement, securities frauds, all of that. So you take, and it's funny, there's a place in here where you have an exception for law enforcement. You know, if somebody's going to be hired for a law enforcement job or for certain other government jobs, you provide an exception. They can consider these crimes. They can get access to the information. But out there in the private sector, if you're trying to deal with somebody who's a scofflaw and a serial embezzler, or maybe serial is not the right word to use, but somebody who's engaged in embezzlement against an employer, I think this automatic sealing, the 1-year time frame, the presumption in favor of doing it, all appears to apply. I would certainly associate myself with the comments, for example, of Mr. Shabbat, who talks about how it's just a continuation of a soft on crime mentality that's just destroying people's lives out in America with burgeoning crime, and you ought to be going the other direction. But how about those specific things? The fact that it seems to be unconstitutional in violation of the First Amendment right of public access to court records in the absence of a compelling government interest and narrowly tailored exceptions, and the fact that frauds don't seem to be, you're just ripping away the protection of people from learning about people who've been inclined toward various forms of fraud when they have to engage in employment decisions. With that, I yield back. Well, I'll see if anybody else wants time, and seeing none and hearing no one volunteering to address the concerns I raised, I guess because it can't be addressed, I'll yield back.
The gentleman yields back for what